Hello everybody, welcome to EPG Pathshala. My name is Monica Sakrani and today we will be going through the first module of criminal law, which is overview of the criminal legal system. This is a part of the course Legal Literacy. The basic objectives, the criminal law modules, there are 5 modules, and the first module introduces you to the concept of criminal law, takes you through what are the major laws which comprise criminal law, and finally tells you about the structure of and hierarchy of the criminal courts. So we begin with looking at what is criminal law. Now normally law is divided into 2 types. One is civil law and the other is criminal law. And we define criminal law as the difference between the two. So we are looking at the difference between the civil laws and the criminal laws. Now, it's not so much, if I ask you what is criminal law, the response may be murder is criminal law, theft is criminal law. If I ask you, give me an example of civil law, you would probably say land dispute or divorce. And so we define criminal and civil law basically as different themes of or different aspects of life which are covered by different laws. But this is not necessarily so. For example, if a woman is being beaten by her husband, she has 2 remedies. One is she can go to the police and she can file a criminal case. At the same time, she can go to a civil court and file for divorce. So it is more in the nature of remedy that is different rather than the act itself may be sometimes similar. So civil law basically is remedial in nature. So she's asking for a divorce or she's asking for maintenance, whereas in criminal law he goes to jail and he gets punished. So criminal law basically is punitive in nature, while civil law is remedial in nature. And you decide what your remedies are, but you cannot decide what the punishment should be. The punishment is given by law. So civil law, the other difference is that civil laws are seen as private wrongs, whereas criminal law is seen as public wrongs. So when we say that can murder be a civil wrong or a criminal wrong, of course it has to be a criminal wrong because of the nature of the act itself. It is so gross, it's so extreme that the state feels that we should prohibit this kind of behavior, and not only should we prohibit it, we should punish anyone who conducts this kind of behavior. So that's why criminal laws basically are mostly public wrongs, and the state takes upon itself the responsibility of prosecuting all serious offences. There may be some offences which may be minor, those are seen as private wrongs, but majority of criminal law is public wrongs, and that's why you have a whole apparatus of the police to investigate the crime and the prosecution to actually see that the accused is punished, and the jail system to see that the state will take care of the punishment and the individual private wronged person doesn't have to do it. The fourth difference between the two, as I had already told you, the third difference is party to decide on the remedy, whereas in criminal law you cannot decide. But the fourth difference is that in civil law we know that, at least in marriage laws, which we will be learning later, there are different laws for different communities. So there may be personal element of laws, personal laws in civil law, but in criminal law the same law applies to everyone, so it is uniform in nature. The last 3 differences, if you look at it, burden of proof on the prosecution, degree of proof beyond reasonable doubt, and right to silence of the accused, are unique to criminal law. Now this is because when somebody is accused of committing an offense, his life or liberty may be at stake, because you can get up to death penalty, as everybody knows in this country, or you can get up to life imprisonment, so you go to jail. So your life and liberty are at stake. So if the burden is on the accused to prove that I have not done something, then all of us can be charged with all the offences in the world, because then we all have to prove I have not done it. Instead of the prosecution making a clear case out that you have done it, we are proving that you have done it, and the burden has to be such that there should be no doubt that this person has done it. It's based on a premise that says that 1,000 guilty men can be released, but not one innocent man should be hanged. So it is based on that premise, and that is why the accused has the right to silence. His lack of saying or giving a defense should not be seen as a complicit as him being complicit in the crime, and therefore he has the right to silence. Whereas in civil law, the defendant, as the opposite party is known, does not have the right to silence, has to present a case, a positive case, and the judge will sift through both the cases and then decide that whom do I believe more, and then give the decision on the basis of that. Now we move on to the next aspect of what exactly is crime. Now generally, if I say that, I give an example, I put a knife into somebody's stomach and that person dies. Now have I committed a crime? If you think or pause for a moment and think, then you will say no, not necessarily. Because it depends on why I put the knife in your stomach. If I'm a surgeon and I put the knife in your stomach to operate you and you die as a consequence of that, I cannot be held guilty for your murder. But if I want to kill you and I put a knife into your stomach and you die as a consequence of that, then yes, I am guilty of murdering you. So there are two aspects to criminal law, and this stems from the legal maxim, actus non facet rem nisi mensit rea. That means an act does not make a person guilty unless his mind is also guilty. So there are two aspects. One is the act itself, and the other is what is your mental intention. Mental intention is known as mens rea. It's a Latin maxim. So act itself should be of three types. One is that it should have a prohibited consequence. There should be an act on the part of the accused, and there should be a causal link between the consequence and the act. So these three aspects have to make the act. Now I say that if I start doing something and I'm not able to succeed because of reasons beyond my control, like I shoot you and you miss and you don't die. So have I not committed murder, and therefore am I not guilty of anything? An attempt to commit an offense is also an offense, though it is punishable with lesser imprisonment. Now we come to the second aspect, which is mens rea. Normally in criminal law, there are three types of mental elements which are held to be culpable. That means they have a penal consequence. Now these three are, primarily it is intention. Intention is the most intense form of mental element. So if I have an intention to commit an offense, it will be taken very seriously. The second is I have knowledge that the act is prohibited, or that this act will lead to this particular consequence, and I still do it for whatever reason without having any intention. For example, I shoot at somebody, or I throw somebody off the cliff knowing that the person, or I throw somebody from the third floor of a building. I know that there is a possibility that the person may die, but at the same time the person may survive also. So I have knowledge, I may not have the intention that I want to kill him, because if I had the intention to kill him, I would take him to the 6th or the 10th floor, where I know for sure that this is what is going to lead to the consequence. And the last is recklessness or negligence. If I'm negligent, if I'm driving a car and I don't care what is going to happen, I just speeding and somebody comes on the way and gets killed, that is negligence. Similarly, a doctor is operating the patient, does not take due care and caution that he's supposed to take, and the patient dies, that is negligence. So these three, both the elements are required in order for an act to become an offense, and the punishment will differ on the basis of one, the nature of the act itself, and the second is the intention or the mental element. So death by negligence is punishable with less of a punishment than death which is intentional. We have looked at the difference between civil and criminal law, but within criminal and civil law itself, there are two types of laws. One is what we call substantive law, and the other is what we call procedural law. Now, the difference between the two is that substantive law is that which creates and defines rights. An example of substantive criminal law is Indian Penal Code, or IPC. Now, what does the IPC do? IPC lists out all the offences, states this is theft, this is murder, it defines what is theft, it defines what is murder, it defines what is rape, it defines what is breach of trust. So it defines the offence and lays down what is the punishment for it. So substantive law basically tells you what is to be done, what is not to be done, and how something is to be done. The second is procedural law. Procedural law tells us that how does the judiciary operate when a breach of law takes place or when somebody wants to exercise their rights. So in procedural law, there are two procedural laws basically in India. One is Civil Procedure Code and the other is Criminal Procedure Code. So Criminal Procedure Code applies to all criminal matters. So how is the trial to take place, which judge will hear the matter, how is the police to investigate, are all written in criminal law. So now if we look at criminal laws, there is a term which you will come across and which I would recommend that you look at if you are interested in knowing more about criminal law. Buy any book which is known as Criminal Major Acts. Criminal Major Acts basically comprises of 3 acts. One is the IPC, which is the substantive law. The second is the Criminal Procedure Code, which is the procedural law, and the third is Indian Evidence Act. So these 3 comprise the Criminal Major Acts. Now the IPC has 23 chapters and 511 sections. I told you all earlier that attempt to commit an offence is also an offence. Section 511 deals specifically with attempt to commit an offence. So any offence which is written in the IPC, if there is an attempt to commit it, like an attempt to murder, attempt to rape, attempt to commit theft, attempt to commit robbery, then that itself would be an offence under section 511. So it describes offences, and that begins from chapter 6 onwards. Chapter 2 to 5 are also of importance because they apply to all criminal laws irrespective. So there are many other criminal laws which are called criminal minor acts. So for example, your trafficking laws, your narcotic laws, your UAPA, there are many laws which are there apart from IPC which define and punish offences. But they are specific kind of offences, like you have the police laws, you have and there are other, like Juvenile Justice Act for example has provisions for what offences written in them. Most labour laws have provisions which say that violation of this is an offence punishable with so and so. So chapter 2 to 5 of the Indian Penal Code applies to all these laws. They define what is punishments, what are general exceptions, and what is abetment and criminal conspiracy. Now we will be looking at general exceptions because what is mens rea and what is not mens rea is defined in general exceptions. The second law, Criminal Procedure Code or Code of Criminal Procedure, sets out the procedure to be followed when an offence is committed, as I have already told you all. It lays down the procedure for investigation and trial of a case, and lays down the powers of various courts and the manners in which appeal can be filed. It also lays down the rights of the accused and how and when arrest can be made. It contains 484 provisions in 37 chapters, and it has 2 schedules. The first schedule is important for us because it tells us, it lists out all the offences in IPC and tells us what is the category of offences, classification of offences. So we will be looking at the classification of offences later on, but for our reference, the first schedule of the CRPC is where we go to when we want to know how the offences are classified. The last of the 3 major acts is the Indian Evidence Act. It has 167 sections. It tells us what is the evidence, what kind of evidence has to be accepted in the court, what are the facts that have to be proved in a trial, and who can be the witnesses, and how is the court to appreciate the evidence before it. Now that we have looked at the 3 major acts, we move on to looking at general exceptions. Now there are many general exceptions of what is not mens rea. I have done the act, but I am not guilty of committing the offence. So what are these exceptions of where the court will assume that you do not have mens rea or you do not have the mental intent to commit an offence? There are many of them. We will look at some of the important ones. Now one of the most important ones is mistake of fact. What is mistake of fact is that I really genuinely didn't know like I picked up your mobile phone thinking it is my mobile phone because we are both of the same make, so it was a genuine mistake of fact, and therefore I have not committed the offence. So I have to prove that general exceptions have to be proved by the accused. I told you all earlier that the burden of proof is on the prosecution. If the prosecution proves that yes, I picked up X's mobile phone, now the burden is on me to prove that I did not know that it was X's mobile phone because my mobile phone is identical to X's mobile phone. So that has to be proved by me. So after the prosecution discharges its burden, then if I want to bring my case to one of the exceptions, then I have to prove it. Mistake of law is not an exception. So I cannot say that, oh, I did not know, I am new to this country, I did not know that murder is an offence, or I have not learnt law, I am illiterate, I never went to college, I have not done my law, so how am I supposed to know that theft is an offence? I cannot take that kind of a defence. The second exception is act of judge. Now judges are also human beings, they can also make mistakes. Judge may not, the higher court may, on an appeal, reverse the judgment over the lower court. Sometimes what happens is there are many cases where a person has been given capital punishment, the person has been hung, and then some evidence comes up which shows that the person was actually innocent. So is the judge now responsible for the person's death? Can the judge be held responsible? Somebody has gone to jail, has spent 2 years, 3 years in jail. Can he come out and say, well, the Supreme Court has said that there's no evidence against me, I should have been acquitted? So can he file a case against the lower court judge? He cannot if the judge is acting in good faith. Acting in good faith means you've acted as per care and attention. I may make a mistake, but that doesn't make me liable for the mistakes I've made, because this will otherwise hamper independence of the judiciary. The third exception that we are looking at is accidental acts. Which is that anybody, I'm driving on the road, I'm not negligent, I'm taking due care and attention, suddenly somebody, a child is coming in front of me, so in order to to prevent the child from being run over by my car, I skid, and then there's a car at the back of me and that bangs into me and somebody gets hurt. So now, is that an offence on my part that somebody has been harmed or hurt because of me? No, because I've acted, it's an accident and I've acted with due care and attention. The next is a very important exception. The next two exceptions are very important exceptions because they relate to the mental ability of a person. So a child up to the age of 7 is held to have no mens rea. He has no mental intention, he will not be able to commit an offence if he does something, because at that age, till that age, it is held in law that he does not know the nature or the consequence of what he is doing, and therefore he does not have sufficient maturity, and therefore anything done by a child below 7 years of age will not be an offence. The second level of maturity is between the age of 7 to 12. There the defense has to prove that the child, even though he is 11 years old, does not have the sufficient maturity to know the nature and consequence of his acts, and therefore then between the age of 7 to 12 the burden is on the child to prove that he had no mens rea. The second one is a person of unsound mind. In this you refer to the DSMs. If it is a mental illness which is recognized by the DSMs, then you can have a defense saying that it was an act of an unsound mind. Now in this particular case, you have to not only prove that you were of unsound mind, but you have to prove that at that particular moment you were of unsound mind, because the law recognizes that every person who may have a mental health issue will also have lucid moments. So that you did not do it in a moment when you were in a lucid moment has to be proved by you. So the burden is on the person. The third exception, the next exception is act of an intoxicated person. But here you cannot get drunk voluntarily or get drugged voluntarily and say that, oh, I was under the influence of drugs or alcohol and therefore I did not know what I was doing. It should have been administered by somebody else, and without your consent, without your knowledge, and then if you do something, then it would amount to an exception to to mens rea. The next important exception is consent. Now, I gave you all the example of a surgeon who is conducting an operation, so he knows there are risks. Or another very good example of consent is sporting incidents. We all know that many sportsmen have died in accidents which have taken place in sports. Somebody, Tiger Pataudi lost his eye. So does that mean that the bowler is responsible for causing harm to him and should go to jail? No. When you take part in a sport or when you get yourself operated, you're giving the consent to knowing that these are the risks involved, and therefore I am voluntarily undertaking these risks. So the person is not responsible for any harm which is caused if you consent to those harms or the possibilities of those harms, including death. If you are a minor, then your guardian's consent is what is required. The next exception is private defense. Now, what is private defense? This is also known as self-defense. Now, basically, criminal law is premised on the fact that, suppose I give you all an example, that somebody comes and kills my son. Do I have the right to go and kill that person's son? Then that would be the law of the jungle. An eye for an eye, a tooth for a tooth, and basically what one would call in modern parlance vigilantism. Now, the law prohibits vigilantism. Now, suppose a person kills my son and I go and kill that person's son as revenge. The law or the criminal law will charge both the person who has killed my son as well as me for murders. And both of us will be punished, and both of us will get the punishment in accordance with law. But does that mean that I can never react, I can never take any steps to defend myself? Now, suppose my son is about to be murdered and there's somebody pointing a gun at my son, or somebody is pointing a gun at me. Can I defend? Can I swerve the gun? And what if in the scuffle that happens, the person dies? Is that murder then? So the answer is no, it is not. There's something called the right to private defense, but the condition should be that one is that I should not have the time to take recourse to law. I should not have the time. By the time the police comes, the incident will have taken place. Somebody is pointing a gun at me. Now, can I call the police? I'll be dead by the time the police are online. So here I have to act immediately. There's no time for me to take recourse to the legal procedure. Then I have the right to private defense. And my right to private defense only extends to the time that I can take recourse to law. Suppose that by the time the police arrive, I can't shoot the person after that. The police have arrived, now it is my right to private defense comes to an end. This is the first condition. The second condition is it should not exceed, I should not use the right to private defense excessively. It should be proportionate to what is required to be done to stop the offense. So, and there are categories of offenses which say that the right to private defense extends to the committing of up to the causing of death of the person, and there are certain categories of offenses, right to private defense, where it does not extend to committing the death of a person. So one is that somebody is causing me harm, so the extent of harm will decide whether it goes up to, suppose somebody is, like for example, stealing my purse. Does that mean I can shoot that person dead? It is excessive, it is not proportionate. But somebody is going to kill me or kill my child, then yes, it can extend to the causing of death. So these are the exceptions. Now, right to private defense also exists for two things, not only in protection of my bodily integrity, but also protection of my property. So these are, somebody has entered into my house and is going to rob me or committing dacoity at night, then yes, I can protect myself, I can harm that person, I can take a stick and beat that person up. Somebody is stealing my purse, I can definitely pull that person and push that person, like hold that person and hand over that person to the police. So I have my right to private defense even for property related offenses. Now we come to this classification of offences. I have told you earlier that this is done as per the Code of Criminal Procedure Code. Now if one looks at offences, basically one can classify it in 3 different ways. One is the most basic classification, which is known as cognizable offences and non-cognizable offences. I told you earlier that criminal law is seen as something so serious that the state itself sees it as a public wrong and decides to investigate and try the offence itself. So it prosecutes the offences itself, and it has a police structure which actually looks at investigation of the offences. So offences are divided into those that are so serious that the state will take cognizance of these offences and will prosecute them, and those which are seen as not so serious and the state does not take cognizance of these offences and does not prosecute them. So these are called non-cognizable offences. Now for us it is important to know is that when we go to the police station, we do not know which is a cognizable offence and which is a non-cognizable offence. The police, if they register an FIR, and they are meant to, they have a duty to register an FIR, as we will be seeing in other modules. They have a duty to register an FIR if a cognizable offence has occurred, and then they start the investigation of the case. Whereas in a non-cognizable offence, they note down the gist of what you are saying in a non-cognizable register or an NC register, and they give you a copy of the NC report. And then you have to prosecute the case just as you prosecute a civil case as a private complaint. The second category, we will be looking at cognizable and investigation processes in our 4th module on criminal law. The second kind of categorization is known as bailable and non-bailable offences. Now bail basically is release of a person after arrest. We will be looking at bail in greater detail in our 3rd module, but bail offences are categorized as bailable and non-bailable. Bailable offences are those where upon arrest you have a right to be released on bail, so you get bail automatically. The police and the court, either of them can grant you bail. In a non-bailable offence, bail is not a right, and these are more serious offences, as one can obviously infer. And here you apply to the court for bail, and it does not mean that you cannot get bail, but there are conditions of bail. We will be looking at it in greater depth in the 3rd module. The third way of categorizing an offence is compoundable and non-compoundable offences. Compoundable offences are those which can be compromised between the parties or settled between the parties, and non-compoundable offences are those which cannot be settled between the parties. Now section 320 of the CRPC lists out which offences can be settled or compromised or compounded and which cannot be compounded. So it lists out all the offences which can be compounded. Now we come to the final segment of our module, of this particular module, which is what is the hierarchy of courts. Now everybody knows that the highest court of the land is Supreme Court of India. Now the Supreme Court has appeal jurisdiction in all criminal matters against all the courts. So suppose you come from the lower court, you keep going higher and higher, you can file an appeal right up to the Supreme Court, and there the court will hear its case and will pass an order. That is the final judgment, beyond which you can of course file for pardon or you can file for review of the case, but appeal jurisdiction is the highest, and it is against the order of the High Court. Apart from that, the Supreme Court also has writ jurisdiction, and it has the power to transfer any case from any court in any part of the country to any other court in any other part of the country. This lower down in the hierarchy is the High Court. High Court also has the power to file writs, as we have already seen in the Constitution modules under 226 and 227. It has appellate jurisdiction over sentence and appeals filed by the Sessions Court, which is the next in hierarchy. It has the power to pass any orders in the interest of justice under section 482 of the Criminal Procedure Code. Apart from that, it has the power to grant bail, cancel bail, modify bail, give anticipatory bail. We will be looking at all this in the 3rd module in greater depth. It has the power to transfer any court within its jurisdiction. As we all know, high courts are there for each state. Generally, there are separate high courts for each state. Some states, 2 or more states may have one particular high court. For example, the High Court of Bombay has jurisdiction over Maharashtra and Goa. Apart from Daman, Diu, the High Court of Punjab and Haryana has jurisdiction over both the states. So there are courts which have multiple jurisdiction over multiple this thing, but they can transfer any case within their jurisdiction. So for example, the High Court of Bombay cannot transfer a case from Delhi to Bombay. Neither can the High Court of Delhi do that. So you have to go to the Supreme Court for that. Apart from that, the High Court can also transfer any case from the lower court to itself and try the case itself. So it has even original trial jurisdiction, and it can, when it decides to transfer the case. So very important matters, the High Court may say that we are going to try the case ourselves rather than have the lower court try it. Apart from that, confirmation of death sentence has to be done by the High Court. Now below the High Court is the Sessions Court. The Sessions Court is there in every district. So generally in every district you have the District and Sessions Court or City Civil Court in metropolitan areas, and they try offences which are punishable with over 7 years of imprisonment. I told you all about the classification of offences. Generally, if you go to the first schedule of the CRPC, it will be written over there which court will try the offence. But the rule is generally that offences punishable with more than 7 years of imprisonment are tried by the Sessions Court. Sessions Court can try any case, but death sentence, if it awards, then that has to go to the High Court for confirmation. Apart from that, it hears appeals from lower courts. It has the power to grant bail, cancel bail, modify bail, and grant anticipatory bail. It also has the power to transfer any court from a magistrate's court within that particular district to another magistrate's court. Now in every district, you also have what is known as the Chief Judicial Magistrate. In metropolitan areas, they are the Chief Metropolitan Magistrates. Now they try offences up to 7 years of imprisonment. They can pass a sentence of up to 7 years of imprisonment. They can't do that beyond that. They also have the power to transfer cases pending in any magistrate's court within them, and they have the power to grant bail, etc. Now the lowest hierarchy of the courts are the metropolitan magistrates, or in metropolitan areas, or the judicial magistrates of the first class. If you look at the CRPC, you will also see a judicial magistrate of the second class, but by and large they don't exist. Even if you go to the Mufassil areas, you will find judicial magistrate of the first class. In legal parlance, there's an acronym JMFC. So if you see a JMFC's court, that is the judicial magistrate of the first class. So they can pass sentence up to 3 years of imprisonment and 10,000 rupees fine. Apart from that, they have the right to grant bail, cancel bail, and to remand. What is remand? We will be looking at in the third module. Now, apart from this apparatus, as we will be seeing in the modules relating to children, there is the Juvenile Justice Act which applies to children. Now, what basically the Juvenile Justice Act says is that the trial of children, or those who are below 18 years of age, and in certain cases below 16 years of age, can only be held by an authority which is known as the Juvenile Justice Board. And this board actually will try all the offences, appeal, and the person who sits on the Juvenile Justice Board is generally a person of the rank of the magistrate. So an appeal from here goes to the Sessions Court. So now we have finished looking at the hierarchy of the courts. We've also looked at classification of offences, and most importantly, we've looked at what is the difference between civil law and criminal law in this module. First module of criminal law, that is your module 11 of the legal literacy course, you will get a more in-depth knowledge. If you are more interested in looking at material, then yes, if you're very interested in criminal law and want to know more about it, buy Criminal Major Acts. They're bare acts. They come from all kinds of publishers. They are easily available at any law bookshop. Also, you get all the laws which are there online. A very good source of legal material is Legal Services India, and there are other websites also where you can get judgments, so you can actually go through all those and get material. Thank you.